Welcome to the second edition of Case by Case, a podcast by Luke Zadkovich and Calum Cheyne of Zadkovich. In this podcast series, we explore various cases, chatting about them as we would internally when they arise, or trying to explain them to clients as we go. We, as you'll see and herein, we kind of give a description about the case, what the decision involves, and some of the highlight points from our experience that we garner from the decision. Today's edition is about a guarantee claim. It's the decision of Mrs. Justice Cockerill, DBE, sitting in the commercial court in England, and gave judgment in March 2021. The parties' names are CVLC, two corporations with that name or variation of that name, and Maritime Petroleum Transport Company. The claimants, the owners of the ships, those are the appellants in this matter, and AMPTC, the defendants, are the guarantors. Before we get into the facts of the case, I just thought to make a couple of opening remarks on this. It's interesting, Calum, that we've got, for our second case of this podcast series, another implied terms decision.
I was thinking the same thing when I was reading it. It comes back to the same point. If you're trying to imply a term, it's difficult. I know there are kind of two things to discuss on this case. There's the procedural question under the kind of right of appeal and the point of law, and there's an interesting procedural question that we'll discuss. But then the substantive point as well, which just comes back to the same point. It's not easy to imply a term under the kind of Marks and Spencer's test, the recent test that the courts will apply when you're seeking an implied term.
Yeah, exactly. And actually, I dare say that we might end up spending more of our time during this episode speaking about the procedural issues than the implied term point. I'm sure you, when you read through this, had a wry grin like I did. That it seemed that counsel for the guarantors realised some of the issues with the substantive implied term arguments and really went hell for leather on the procedural arguments.
Yeah, agreed. Which gives us a good case on procedure and clarifies an important procedural point. But it does seem to be, as you say, that they identified that perhaps the question wasn't put properly on the implied term or wasn't considered in the context of the Marks and Spencer's case in the arbitration. It's always slightly difficult with the cases that get to the High Court from appeal because you never get the full picture from the arbitration. You get clips from the arbitration award, and you get a sense of how things proceeded in the underlying arbitration. But obviously, the context of this arbitration was quite important to the whole discussion in the High Court and the urgency with which the arbitration proceeded.
And I think that's one of the key takeaways from this decision as practitioners thinking about, well, what were the legal issues that were dealt with in this particular decision, but also practically, what can we take away from it and learn and use in our own practice on other cases? And the point that I took, amongst others, was it's quite important in arbitration, where in English arbitration, where you have the ability to appeal on a point of law, to think about how you are putting questions to the arbitrator. Are you putting them as questions of fact? Are you putting them as questions of law? Are there mixed questions of fact and law, particularly on an expedited preliminary issue like this, which could quite conceivably end up in an appeal scenario? And that was one of the kind of key issues that I took away from this. Before we get into that, Calum, and I'll hand over to you if that's okay to give a quick summary of the facts. I just thought for our listeners, a point of procedure on these podcasts. Calum and I, we haven't discussed this case at all prior to jumping on the podcast. We each read the case, make some notes ourselves, and then jump on to the recording and see what we each made of the case. So it's usually our first crack at it, and see what we take away from it. So with that said, do you want to give a short summary of the case?
Yeah, let me go through the facts and maybe just the decision as well. So as you said at the top, the key parties involved here, you have the owners of the vessel, and the owners chartered the vessel onto charterers, or two vessels onto charterers, and those two charterers guaranteed their obligations under these bareboat charters. The owners alleged that there was a breach of charter, and the charterers were in default. Owners tried to claim under the guarantee, and the guarantor didn't pay out. So owners then sought security and ultimately arrested the guarantor's vessel in Angola. The question for the arbitrator, on very short notice it seemed, was whether the owners were entitled to security under their guarantee, i.e. could they have security for their security? And owners said, for a number of reasons, that they weren't entitled to have security for their security. I think we'll come on to those questions in a while. But it seems like one of these situations where the arbitrator was really pushed to make an award at very short notice, and the judge makes it very clear in this award that in this judgment that the underlying arbitration was decided very quickly, and that, as often happens in these in a kind of expedited hearing or an expedited decision, the goalpost can move quite quickly, and almost as you plead it, you're kind of working out what arguments you want to raise. It's like you said earlier, like you have to be really clear about these things, because and it's difficult to do that under the time pressure that these parties were under in the context of an arrest. But then when someone's picking over the bones of that urgent, short notice arbitration award, they're doing so with the benefit of time, and it's the benefit of time that these parties didn't have when they were kind of disputing the original question of whether or not there was an entitlement to apply to make an application to obtain security for their guarantee.
Yeah, exactly. And if we can just unpack that a little bit before we move on to more of the facts, there's a point to take away from this, in that arbitration is not, let's say, well suited to dealing with urgent, expedited applications like this. It's possible to do it, and we clearly saw that it was achieved in this case, albeit various issues arose from it, including points of argument, form of argument, and others. But as a matter of procedure, particularly in London LMAA maritime arbitration, there's not good, robust procedures around expedited applications, and it's not commonly done. There's often issues around whether both parties have had an opportunity to appoint their arbitrator. That has to play out if a sole arbitrator is not agreed, as it was here. There can then be questions as to, well, is the arbitrator being asked to take a view on merits in the context of an expedited application without full evidence, and then almost prejudging a case before they've had the benefit of testing the evidence. In this case, we see that the arbitrator was at pains to not prejudge the evidence and expressly said in his award that he was not considering evidence. But then that raises other problems, because the question of whether to imply a term or not, it can be strictly a legal question, but often it involves questions of facts as well. And I thought from that, it's interesting how if this type of application would have been brought in court, there would be strict rules around what evidence should be put in place or put with the application in support and what evidence would then go in by way of response to the application. Whereas those things are not as clear in arbitration from a form and procedural perspective. And then that creates pleading issues and questions as to what was the issue actually before the arbitrator, particularly when in English arbitration, you can only appeal to the courts on a point of law, not on a question of fact, but on a point of law. And so it's quite important. What was the decision that the arbitrator had reached that you want to appeal?
I would just jump in there. There's a very good kind of essay on this, and I'll put it in the show notes when we upload the podcast, by, I think it's Michael Collick QC and a few others, talking about urgent applications in maritime arbitration. And it's exactly as you say, the setup for these urgent applications, it's not really the intention of the arbitral system. It's not really optimized for this kind of urgent application, which then, as you say, gives rise to these factual issues. And essentially we had a question in the arbitration, which was on the basis of all these different facts, can we imply a term into this contract? And the arbitrator essentially said, I don't find that any of these facts, I can't make a finding on any of these facts because I don't have the evidence, but I can make a finding on the existence of this implied term. And that was what led to the kind of first procedural issue, which was at the first stage in the process of appeal. The entire appeal process was contested on the basis that the question that was appealed was formulated in a different way to the question that was initially asked in the arbitration. It might, before we get into that, maybe we should step back and talk about the process for appealing an arbitration award.
Yeah, I think that's a good idea. And I'll open this up. We're dealing here with an English arbitration. And under the English Arbitration Act of 1996, it is possible to appeal, and I use the word appeal, not challenge, but appeal an award issued by an English arbitral tribunal to the English Commercial Court. And that's done through Section 69 of the Arbitration Act. There are other bases upon which you can challenge an award under 68, procedural irregularity, and there can be other types of challenges to an award. But what's unique about the English arbitration process in this respect is that you can actually appeal on a point of law. That is not the case in other jurisdictions. Some other jurisdictions do have appeals, but there is a tendency in many other jurisdictions, the United States, for example, not to allow appeals to the court system, the supervisory court system. In the US, for example, you have to satisfy the manifest error test to challenge an award, a much higher threshold. Here, you have in England the possibility of appealing on a point of law as you would appeal other issues through the court system. It is still a high bar, and there are thresholds involved in satisfying the court that there's a legal issue that's of sufficient general importance, and other tests as well. But the basic point, I think, that our listeners will be interested in is that in England, it is possible to appeal on a point of law.
Yeah, and the one point I'd add to that is that parties can contract to disallow an appeal on a point of law, but typically in most charter party contexts, you don't see that. The only place where I would say you sometimes see it creeping in, almost by the back door, is in certain longer term energy related charter parties that have the LCIA as the venue for the arbitration, because under the LCIA rules, the parties do contract out of their ability to appeal on a point of law.
Yeah, and you also see, without getting too off topic, you see in commodities arbitrations in GAFTA and FOSFA that sometimes there's an internal appeal process within the institutional rules that allows for an appeal from a single arbitrator to multiple arbitrators within the GAFTA process or the FOSFA process. You see that. Sometimes in commodities arbitrations as well. But from a kind of general perspective, I think the main point that we're making here is that typically it is possible to appeal from a London arbitration to the court system on a point of law. And that's what we're dealing with here.
Yeah. So the method for that appeal is then set out in Section 69 of the Arbitration Act 1996. And under Section 69.3, as you mentioned, that there's this burden on the party appealing to satisfy the court of certain conditions, to meet certain hurdles. The first is that the question that they're asking to determine has to substantially affect the rights of one or more of the parties. I.e., it basically you have to be appealing something which is critical to the judgment or to the arbitration award. Otherwise, there's no reason for the court to get involved. The second thing is that, and this is what was critical in this case, is that the question that you're asking the court to decide, the question that you're appealing to the court, has to be one that the tribunal was asked to determine. And that's under Section 69.3b of the Arbitration Act. And the third one, just to round it off, is that you have to show the court that the decision of the tribunal was either obviously wrong or that it was open to at least serious doubt, and that the question is of general public importance. And in this case, you had a situation where the question that was asked on appeal was kind of characterized slightly differently to the way that the question was put to the arbitrator in the arbitration. And it was contested. The appeal was contested by charterers because they said it simply doesn't meet the threshold. The way that the question is posed to the court on this implied term is posed purely as a question of law. And it's not the question that the arbitrator was trying to answer, because the arbitrator was trying to answer this factual question. And the first step in this appeal process, the kind of first stage, if you like, is to get permission to appeal. And the second stage is then to have the substantive appeal hearing. And the permission to appeal hearing is usually slightly shorter. There's not quite the depth of thought that goes into the full hearing on appeal. But at the permission to appeal stage, the judge says, yes, this satisfies the test, and it's going to go ahead to a full appeal. And then at the second stage, at the kind of substantive question, at the substantive stage where the parties were discussing the issues, the charterers again said, we want to question the kind of veracity of the judge's decision to allow leave to appeal. We want to go back and reopen that question that they dealt with at the permission hearing. We want to say, is it a substantive ground to kind of challenge the appeal at the appeal hearing that the permission was wrongly granted, effectively?
Yeah, and that was interesting in this case because somewhat unusually, it was the same judge who was dealing with the permission application and then went on to deal with the substantive appeal. And it's a classic case of English advocacy, as I see it, where you've got an eminent QC, Mr. Berry QC, making submissions on behalf of the guarantors, seeking to say why the original decision on the permission application was wrong, before the very same judge on the appeal application, and how to do that tactfully, and then for the judge to Mrs. Justice Cockerill to navigate her way through, saying, well, I think I was right the first time and the second time, and I don't find your arguments now any more convincing than I did the first time. But the point, I think, as a matter of law to take from that is that actually, even if it had been a different judge, the test when it comes to deciding the substantive appeal and the process that the judge is going through at that second stage is not really about revisiting the permission decision. And there needs to be something really fundamentally wrong with what the judge did in the first decision granting permission to revisit that. The courts devote time to the permission application. They're given significant thought, and if a decision is made that a case, which we know the statistics on successful permission applications on these appeals from arbitration awards, and they're low. Not many get through to the court to be dealt with on a substantive appeal. So when they do, the court's more interested at the second stage of dealing with the appeal itself rather than revisiting the permission decision.
Which makes total sense, I think. By the time you get to that stage, you've got to get on and deal with the substantive points. You've lost the permission. You've lost it at the permission stage, and you've got to go ahead and deal with the question that's being put to the judge and try and win on substance.
Yeah, exactly. And what was interesting, we touched on this right at the outset, is that the guarantors during oral argument on the substantive appeal, and we see this happen in many different cases, they focused in on the jurisdiction question and really wanted to assess whether the question that is now before the court on appeal was actually put before the arbitrator or not. And the reason it seems that they put so much emphasis on that aspect, the jurisdictional type argument, is because their implied term argument was not strong. And I think that was recognised by one and all probably during argument. And hinted at by the court in the decision. And that's really this question of whether the final question as formulated for decision by the court was a question put to the arbitrator. Now, when I say the final question was put to the arbitrator, that does not mean that the exact formulated legal question that the court is deciding yes or no on was put in those express terms to the arbitrator. And that's what this decision goes to on this point, is that what the court's looking at was it intrinsic in the issues that were before the arbitrator? Was it kind of there and thereabouts? It doesn't have to have been put in express terms. And did the arbitrator consider it? And did the arbitrator make a decision on the issues that are kind of underpinning, if you like, the question as ultimately formed? And the one point I'd also like to make on this is that the final formulation of the question that the judge decided in this decision was not even the exact formulation put by the appellants. The appellants had it slightly differently, involving some questions of fact and law, and the judge, in deciding the permission application, redrafted, if you like, the question that should be decided by the court, and that really stripped the question away to being a question of law.
And that happens quite a lot. It's quite often that you read a judgment where it's a Section 69 appeal, and it starts saying there was a request for permission on this basis, but the judge deciding permission actually thought that this was a more interesting question or a more relevant question or just a better way of writing the question. And that, I think, was a factor in the way that the judge decided that effectively they had already met the test at section 69. It was sufficiently close, essentially, to the question that was asked in the arbitration to effectively be the same question, particularly where in the arbitration, although it was framed as a question on fact and law, the arbitrator said, I'm not capable of making a determination on the facts on the basis of the evidence before me. So really, he proceeded on the basis, proceeded to make a decision on the basis of a legal question.
Yeah, exactly. And so the decision takes quite a bit of time on dealing with this point. But ultimately, I think the decision is quite a straightforward one on the question of was this question put before the arbitrator, and it clearly was. Should we set out what the implied term was, Calum, and just read out what the actual term was that the court was considering?
Let me just turn to the exact term. Yeah, so
here we go. I've got it here. So we're at paragraph 16 of the judgment. And so the reformulated question was this: is there to be implied into contracts of guarantee and indemnity which, one, guarantee the performance of another contract, and two, are expressly given in consideration of the beneficiary entering into that other contract, an implied term that the creditors would not seek security over and above that provided by the contracts of guarantee and indemnity, where the guarantor is or is alleged to be in breach of the contract of guarantee and indemnity. Let's just break that down, I think, Calum. It's quite a long sentence.
So, I mean, cutting through it slightly, we've got a situation where two parties enter into a contract, say Party A and Party B. Party B, as part of Party A entering into the contract, they say, Party B, you must also put up a guarantor. Party B does put up a guarantor, and later on down the road, the Party B breaches its obligations or is alleged to have breached its obligations by Party A, and the guarantor then fails to pay under the guarantee. And the question is, can you then go after the guarantor for further security? And in the kind of maritime context, that further security is often the process of attaching or arresting a vessel, and seeking security on the basis of that attachment.
Yeah, and that's the key point. Is actually it's this last part of the formulated question where the guarantor is or is alleged to be in breach of the contract of guarantee and indemnity, and that's really the crux of it for me. Is that what the guarantors sought to argue here ultimately on the implied term was a couple of things. That they were trying to argue that this is a double security type scenario, that the guarantee itself was the security, and that's the end of the story. And I've got a lot of troubles with that type of argument. But the other argument that they were making is that if this implied term was there, it would mean, and if you could get security on the guarantee, it would mean that immediately upon entering into this arrangement, the owners could be unsatisfied with the security provided by the guarantor and go and seek further security, this additional security on top of the security. And I think that really misses the point. And in the reformulated question, those last words really go to this. We're not talking about a non-breach scenario by the guarantor. We're talking about a scenario, as you describe, where the charterers are in breach of their obligations to the owners, or alleged to be in breach of their obligations to the owners. The owners then look to the guarantor. There's a prima facie breach, an alleged breach. The guarantor does not pay. The guarantor, as a primary obligor, is then in breach of the guarantee, or at least alleged to be in breach of the guarantee. And the question is, can the owners then go get security for their guarantee claim against the guarantors? So, and it's an unusual case in a way, but not so much. And the judge goes to this, is that often you're not looking at trying to get security in a practical sense from a guarantor, from a P&I club or from an insurance company, because they're good for the money. But when the guarantor is a company where you might have some concerns about financial stability, and I'm not making any aspersions about the guarantor in this case on that, but clearly the owners thought that they needed to get security from this guarantor. The question is, what prevents, or what should prevent, or could prevent the owners from going and getting security for that guarantee claim? And more to the point, should a term be implied into that contract, which would be exclusionary in nature, to say, because the guarantee is itself security for another contract, for the charter parties, that prevents, or that should mean that there's an implied term excluding the ability of the owners to get security from the guarantor for the guarantee claim, not for the charter party claim, for the guarantee claim. And when it's unpacked like that, it seems like a pretty straightforward answer to that, frankly.
Yeah, I totally agree. When you put the question in the way that it was put for the purposes of this appeal, it is straightforward. The argument that was put by the argument that was put forward by the guarantors is kind of referred to in the judgment, and they say, I think it's kind of instructive to read it out. They say the guarantees were security. The claimants had the security they contracted for. They were secure. It is contrary to commercial common sense that they can get security for the security which they agreed was adequate. The question can be tested by asking the logically identical question, whether they would be entitled to get security for the security by arresting club assets. Of course not. And what they're talking about here, and I think this is where it starts to unravel, because the judge says, no, that's obviously not correct. But what they're talking about here is that having arrested the guarantor's vessel, a P&I club then provided, I think it was a club LOU. And that club LOU, the argument went from the guarantors. They said, if you allow the party to seek security for their security, then they can immediately go and arrest the assets of the P&I club. And the judge said no, that they could only go and arrest the assets of the P&I club if the P&I club was alleged to have defaulted under their LOU. But the other point that I would make on the question of the P&I club's involvement is that, as far as I can recall, every single club LOU that I've seen has express provision to say that no further security is allowed in respect to the claim. It seems like something which is, it's not something that I've always paid a great deal of attention to, so it may not be something which is there all the time, but certainly, as far as I can recall, everyone that I've seen, you get your security for the claim, and the club says, in the club LOU, it says that's your lot, that is your security, but it's an express claim, it's an express provision, and it needs to be an express provision because it doesn't come anywhere close to meeting the implied term test.
Yeah, and in a way, it is a bit of an imperfect analogy, because a club LOU is typically put up post-arrest or post-threat of arrest, and certainly post-claim. And what we're talking about here, of course, is a guarantee that's put in place right at the outset. And so it's not a great comparison. And in any event, when you're looking at a club LOU, the question as to seeking security from at least IG, international group P&I clubs, just doesn't arise, because there's almost like a cardinal rule. I know this from my time at one of the IG clubs myself, as a cardinal rule. I don't know if it's policy or not. It's maybe not formal policy, but that they have an inherent interest in honouring club LOUs around the world, because they want to present to the industry, particularly in certain jurisdictions that might have less comfort in accepting LOUs for releasing ships, that they're good, that they're going to be honoured, that they're not going to be challenged down the track. And so there's almost this overriding approach to club LOUs that we're going to honour them. We're not going to try and take technical points that sometimes you might see under a different form of security in other industries. So yeah, look, I think when you unpack it in that way, it just doesn't stand up to scrutiny. And when you look at the actual test for an implied term, I think the initial reaction to this, or the commercial approach, just it becomes even less compelling. And we touched in the last episode on the Marks and Spencer decision, but I thought the reference to the Ali and Petroleum Company of Trinidad and Tobago 2017 decision is also worth touching upon, and this is in the context of the test for implying a term. And that it's the types of tests here are that the term is only to be applied if it is so obvious that it goes without saying. That's certainly not the case here. And the second one is that it is necessary to give the contract business efficacy. And we've noted before, usually the outcome on either of those tests is the same, but it is an and/or test. And the arbitrator does refer to business necessity in the award. We haven't seen the full award, obviously, and we've only seen what's in this decision. And the judge does go through and look closely at the references to business necessity, and was not satisfied that the arbitrator entirely went to the test as had been set out in the authorities. And the concept of necessity must not be watered down. And it's not about showing that the contract would be improved by this additional term. And yes, fairness and equity are usually essential to implying a term, but they're not a sufficient precondition for inclusion. And you've got to go back to those two key tests. So I think it's useful to look at it in that context. It's also useful to think that this is not a unique contract in a sense. It's boilerplate type language that was used that is typical in many guarantees, as I know you and I have seen before, and the judge noted. It's also the implied term that the guarantors are asking to be implied into this contract is that of an exclusion clause. The exclusion of the ability to seek security on the guarantee claim. And when you're asking for a term and it to be implied into a contract that takes away common law rights and remedies, the bar is very high. And this clause, the term in this test, just doesn't get close, in my view, to getting to that level.
Yeah, I think that's right. And so on the substance, really, when you look at the reformulated question, is this term going to be implied? Is it implied into contracts of guarantee and indemnity that the creditor cannot seek security over and above that provided by the guarantee? Well, no, because why would it be? And it strikes me as a question where it's at least highly questionable. It certainly doesn't meet the obvious threshold. I don't see the need for business efficacy to be given to it. So yeah, unless the parties choose expressly that there is to be no further security given, in which case they can include it in the contract of guarantee and indemnity, then I think there's no reason to imply that term. And I think the judge got this right.
Yeah, I agree, Calum. I entirely agree. And the other interesting point, kind of my parting shot on this, is the question that was posed at para 84, where, well, it's difficult to see that if the owners are entitled to go and get security from the charterers and arrest vessels, or get security under the primary claim, why they can't also go and get security from the guarantor when they're also a primary obligor. They're not a surety; they're a primary obligor, and so it's difficult to kind of square that away. So, look, I found this another interesting decision. It allows us to get into appeal procedures in England and also touch on implied terms again. I think we should make a promise to our listeners not to touch on implied terms in the next one, but I thoroughly enjoyed catching up on it again with you, Calum.
Yeah, absolutely. Me too.
Thank you all for listening. Until the next one, take care.
Cheers.